that promises to redefine the national debate on civil liberties and free speech. We're honored by you being here, and we ask you to be our first witness, and all the statements of all of our witnesses will be introduced in their entirety into the record. Welcome.
Chairman Conyers, Judge Gohmert, members of the committee, thank you very much for inviting me and giving me this opportunity to speak with you about these issues. What I'd like to do is address the constitutionality of the proposed SHIELD Act, which has been introduced in both houses of Congress. The SHIELD Act would amend the Espionage Act of 1917 to make it a crime for any person knowingly and willfully to disseminate in any manner prejudicial to the safety or interest of the United States any classified information concerning human intelligence activities of the United States. Now, although this act might be constitutional as applied to government employees who unlawfully leak such material to persons who are unauthorized to receive it, it is plainly unconstitutional as applied to other individuals or organizations who might publish or otherwise disseminate the information after it has been leaked. With respect to such other speakers, the Act violates the First Amendment unless, at the very least, it is expressly limited to situations in which the dissemination of the specific information at issue poses a clear and imminent danger of grave harm to the nation. The clear and present danger standard in varying forms has been a central element of our First Amendment jurisprudence ever since Justice Oliver Wendell Holmes first enunciated it in his 1919 opinion in Schenck versus United States. In the 90 years since Schenck, the precise meaning of clear and present danger has evolved, but the principle that animates it was stated eloquently by Justice Louis Brandeis in his brilliant 1927 concurring opinion in Whitney versus California. Those who won our independence, wrote Brandeis, did not exalt order at the cost of liberty. They understood that only an emergency can justify repression. Such, he said, must be the rule if authority is to be reconciled with freedom. Such is the command of the Constitution. It is therefore always open to challenge a law abridging free speech by showing that there was no emergency justifying it. This principle is especially powerful in the context of government efforts to suppress speech concerning the activities of the government itself. For as James Madison observed, a popular government without popular information, or the means of acquiring it, is but a prologue to a farce or a tragedy, or perhaps both. As Madison warned, if citizens do not know what their own government is doing, then they are hardly in a position to question its judgments or to hold their elected representatives accountable. Government secrecy, although surely necessary at times, can also pose a direct threat to the very idea of self-governance. Nonetheless, the First Amendment does not compel government transparency. It leaves the government extraordinary autonomy to protect its own secrets. It does not accord anyone the right to have the government disclose information about its actions or policies, and it cedes to the government considerable authority to restrict the speech of its own employees. What it does not do, however, is to leave the government free to suppress the free speech of others when it has failed itself to keep its own secrets. At that point, the First Amendment kicks in with full force, and as Brandeis explained, only an emergency can then justify suppression. We might think of this like the attorney-client privilege. The client is free to keep matters secrets by disclosing them to no one. He's also free to disclose certain matters to his attorney, who is under a legal obligation to respect the confidentiality of her client's disclosures. In this sense, the attorney is sort of like the government employee. If the attorney violates the privilege by revealing the client's confidence, say, to a reporter, then the attorney can be punished for doing so. But the newspaper cannot be constitutionally punished for disseminating the information. Now, some may wonder whether it makes sense to give the government so little authority to punish the dissemination of unlawfully leaked information. But there are sound reasons for insisting on a showing of clear and present danger before the government can punish speech in this context. First, the mere fact that the dissemination of such information might, in the words of the proposed act, in any manner prejudice the interest of the United States, does not mean that the harm outweighs the benefit of publication, as Chairman Conyers noted. In many circumstances, such information may indeed be extremely valuable to public understanding. Second, a case-by-case balancing of harm against benefit would be unwieldy, unpredictable, and impracticable. Clear rules are essential in the realm of free speech, and indeed that's one reason why we grant the government so much authority to restrict the speech of its own employees, rather than insisting that in every case the government demonstrate that the harm outweighs the benefit. Third, as we've learned from our own history, there are great pressures that lead both government officials and even the public to overstate the potential harm of publication in times of national anxiety. A strict, clear and present danger standard serves as a barrier to protect us against that danger. And finally, a central principle of the First Amendment is that the suppression of public speech must be the government's last rather than its first resort in addressing a potential problem. If there are other means by which government can prevent or reduce the danger, it must exhaust those other means before it can even entertain the prospect of suppressing the freedom of speech. In the secrecy situation, the most obvious and the correct way for government to prevent the danger is by ensuring that information that must be kept secret is kept secret and is not leaked in the first place. Indeed, the Supreme Court made this very point less than a decade ago in a case known as Bartnicki versus Vopper, in which it held that when an individual receives information from a source who has obtained it unlawfully, that individual may not be punished for publicly disseminating the information, absent the need of the highest order. The court explained that if the sanctions that presently attach to the underlying criminal act do not provide sufficient deterrence, then perhaps those sanctions should be made more severe. But it would be, the court said, quite remarkable to hold that an individual can constitutionally be punished merely for disseminating information because the government itself failed to deter conduct by a non-law-abiding party. This may seem a disorderly situation, but the court has in fact come up with a good solution. If we grant the government too much power to punish those who disseminate information, then we risk too great a sacrifice of public deliberation. If we grant the government too little power to control confidentiality at the source, then we risk too great a sacrifice of secrecy. The solution is thus to reconcile the irreconcilable values of secrecy on the one hand and accountability on the other, by guaranteeing both a strong authority of the government to prohibit leaks and an expansive right of others to disseminate information to the public. The bottom line, then, is this. The proposed SHIELD Act is unconstitutional. At the very least, it must limit its prohibition to those circumstances in which the individual who publicly disseminates classified information knew that the dissemination would create a clear and imminent danger of grave harm to our nation or our people. Thank you. Thank you, Mr. Chairman. I think it's very important not to get fixated on this question of does the speech cause some harm. One of the things that the Supreme Court figured out pretty quickly is that almost all speech causes harm. It's not harmless. And so it made a terrible mistake during World War I, which is that it took the position that because criticism of the war would undermine the morale of the American people, it might lead people to refuse to accept induction into the military, that speech could be punished because it might have a harm. And what they figured out pretty quickly after that is that was a disaster. That you can't prohibit speech that criticizes an ongoing war because it might have harm. Speech does have harm. And the Pentagon Papers case, although the court said there was not likely an imminent grave harm, even Justice Stewart conceded the speech was harmful. Certainly we were revealing all sorts of confidential information about the past, that we had double-dealed with respect to some of our allies, that we'd made alliances that hadn't been publicly disclosed before, that made it more difficult for us to negotiate in the future. If the standard focuses on harm generally, then you've given up the First Amendment. That's right. I think it's important here, again, to distinguish between...
So are we talking about a good faith exception to leaking?
I think it's important to distinguish between the leaker and the publisher. The leaker can be regulated, consistent with the First Amendment, much more aggressively. And there I think it's sufficient to say that knowing disclosure of classified information that's properly classified, punishable.
Congressman, one more thing on your last point.
There's great benefit in having a very rigorous and narrow statute to punish the publication of the information, because that puts pressure on the government to keep the secret in the first place. So they can't punish WikiLeaks because they don't have the requisite intent or they haven't caused the requisite harm. And they know that, and they're serious about the secrecy. They will then take the steps necessary to keep the information secret. And in that dynamic, I think it's very important not to make it too easy for the government to try to prosecute the ultimate speaker, because if they can do that, then they'll get lazy and sloppy on the question of secrecy itself. Sure. Well, I think that the government's ability to regulate the activities of its own employees who've signed secrecy agreements is considerable, and that's where the focus should be, on keeping that information secret if it really needs to be kept secret. That once we move into the realm of public discourse, then we should be extremely careful, and the First Amendment demands that we be extremely careful. Mr. Schoenfeld a number of times has identified the Chicago Tribune incident from World War II, where the Tribune published information that revealed the fact that we were aware of a Japanese secret code, and we've been using that as a way of advancing our own war aims. And had that information been made available to the Japanese, as it could have been given the fact that it was published, that would have been, in fact, a situation where there was a clear and imminent danger that posed a grave harm to the United States. We would have lost a pivotal benefit in fighting World War II. And that seems to me the paradigm case for a situation where the knowing disclosure of that sort of information can be subject to criminal prosecution. But the key to that example is that it happens once a century. Nothing in the WikiLeaks case comes close to that. And it's important to say that's the situation where you can go after publishers or disseminators of information who are not in a special relationship with the government. And that almost never happens, and when it does happen, it merits punishment. But beyond that, we should be focusing our attention on the situation of keeping information secret in the first place, in-house, in the government, where secrecy is necessary.